2 million removals or self-deportations in a single year. If you heard that number and felt your stomach drop, you are not alone. Because if it is even close to accurate, it signals an enforcement environment where small mistakes get punished fast, families get separated faster, and employers may start losing key workers without warning. In this video, I am going to do 3 things. First, translate what that headline actually means in plain English, including the difference between removals and self-departures. Second, I will break down who is most at risk right now and who is usually not, because confusion causes panic. And third, I will give you a practical checklist of safe steps you can take this week to reduce preventable problems, especially if you have a pending case, expiring status, or travel coming up. Here is the part most people miss. Big numbers can be used to tell very different stories, depending on what is being counted, who is being counted, and whether the data is verified. So we are going to separate what we can verify from what we cannot confirm yet, and focus on what you can control. Now, let us start with the core claim. The brief you saw says the US government has reached a grim milestone, 2 million removals or self-deportations this year alone. That is 2 very different buckets. A removal, in everyday terms, is when the government formally forces someone out or orders them removed through a process that results in a removal order or expedited removal. A self-departure, sometimes called voluntary departure or simply leaving on your own, can mean someone exits the US without being physically removed by officers, sometimes after being told to leave, sometimes after deciding they cannot stay, and sometimes because they are afraid. Those categories can overlap in public narratives, but they are not the same. And for your future immigration options, they can have very different consequences. This is where people get denied, when they treat a headline number like a single, clean statistic. If you are trying to understand your risk, you need to know what kinds of actions are driving that number. Is it mostly border removals? Is it interior enforcement? Is it people leaving because their work authorization ended? Is it people exiting after a notice to appear? Without that breakdown, you cannot map the headline to your situation. So what changed, in the practical sense, if enforcement is surging? Typically, a surge means some combination of more arrests, faster processing of removals, more use of expedited processes where allowed, more coordination with local agencies, or more aggressive issuance of charging documents like NTAs, which are notices to appear in immigration court. It can also mean more pressure on employers through audits, more scrutiny at airports and land borders by CBP, and a more unforgiving posture toward missed deadlines, missing documents, or status gaps. Now let us talk about the groups that tend to be affected first, because 2 groups are at highest risk in a crackdown environment: people with a clear status gap and people who accidentally put themselves in front of immigration officers without realizing it. Status gap means you do not currently have a valid non-immigrant status, you do not have a pending application that provides authorized stay, or you are relying on a document that is expiring or has already expired, like an EAD, parole, or a period of admission. The second group, people who put themselves in front of officers, often includes travelers returning from abroad, people who have an appointment with an agency without preparation, or people who have a traffic stop that escalates because of identity issues, prior orders, or outstanding warrants. If you are watching and you are a student, a worker, or part of a family-based process, here is a quick map of who is affected versus who is not. Affected more often: people with prior removal orders, including old in absentia orders, people with prior deportations or expedited removals, people with criminal convictions or pending charges, people who recently entered and are in a fast-track process, people whose status ended and who did not file something timely, people with denied asylum or denied renewals who did not get a new legal foothold, and people whose protection programs are being changed, paused, or litigated. Affected sometimes, depending on details. People with pending adjustment of status who travel without proper authorization, people with a pending asylum case who travel, people with expired passports or inconsistent documents, and people who work without authorization and later seek a benefit that requires proof of lawful work history. Less likely to be directly targeted in most enforcement narratives, but still not immune. US citizens, obviously. but also many lawful permanent residents who are not triggering criminal grounds. People in valid status who keep their documents current, and people with well-prepared pending filings who are not traveling or creating new risk events. Here is a myth versus reality moment. Myth: if you have a receipt notice, you are safe. Reality: a receipt notice is not a magic shield. It depends on what you filed, whether it was timely, whether it was properly filed, and whether it gives you authorized stay or work authorization. Another myth: if you have never been arrested, you cannot be removed. Reality: removal is an immigration process, not a criminal conviction requirement. Overstays, status violations, and certain kinds of misrepresentation can create removal risk even without an arrest. Now, the brief also mentions Venezuelan engineers and AI researchers losing temporary protected status. TPS is a humanitarian program that can provide temporary protection from removal and work authorization for nationals of designated countries if they meet eligibility requirements. If TPS is changed, terminated, or if someone loses eligibility, the risk is not that you are instantly deported the next day. The real risk points are more practical and more immediate. Your work authorization can expire. Your driver license renewal can get blocked in some states. Your employer may have to re-verify work authorization. You may lose the ability to travel and return. And you may become removable if you have no other valid status. This is the detail that changes everything. If you have TPS and you also have another valid status, like H-1B, F-1, or pending adjustment with advanced parole and EAD, your planning options are very different than if TPS is your only protection. So if you are in that TPS category, the first question is not panic. The first question is, what is your current legal basis to stay and work today, and what is the next expiration date on paper? Next, the brief claims new presidential proclamations impose massive fees on H-1B petitions to prioritize American hires. I need to be careful here. Without an official document cited, we should treat that as reported or alleged. H-1B costs can change through legislation, regulation, or fee rules, and sometimes there are proposals, lawsuits, and drafts. The safe approach is to verify. Do not rely on viral posts. Check USCIS official fee pages, the Federal Register for published rules, and Employer Council updates that cite sources. If any new fee is real, the immediate impact tends to be: employers file fewer petitions, delay hiring, or shift roles abroad. But even then, the details matter. Who pays, when it applies, whether it affects extensions, amendments, cap subject cases, or cap-exempt employers. That is why I am not going to pretend a specific fee amount is confirmed if we do not have it in the source material. Here is another myth versus reality. Myth: higher H-1B fees automatically mean fewer foreign workers and more American jobs. Reality: sometimes it means fewer hires overall, slower growth, or offshoring. Some employers will pay higher fees, but many will move projects or hiring to Canada, Europe, or remote hubs. The economic argument in your brief is that protectionism can drive innovation and jobs overseas. That is a real concern many economists and labor experts raise in general, especially in AI and biotech, where talent is global, capital is mobile, and timelines are short. But we should also acknowledge the safety argument officials often make, that enforcement restores order, deters unlawful entry, and focuses resources on threats. Both can be true in parts. The question is how broad the net is, and what collateral damage happens when enforcement capacity expands. Now let us talk real-world consequences, because this is where families and employers feel it first. Consequence number 1: travel gets riskier. Not for everyone, but for people with prior overstays, prior denials, prior removal orders, or uncertain status. CBP has wide discretion at the border. Even if you have a visa or a green card, CBP can ask questions, review your phone, examine your work history, and look for inconsistencies. In a heightened enforcement period, discretion can feel tighter. Consequence number 2: timing mistakes get more expensive. If your EAD renewal is late, if your I-94 expired, if your school DSO did not update something correctly, If your employer filed an amendment late after a worksite change, those are the kinds of technical issues that can cascade. Consequence number 3, employers get cautious. If the environment signals more audits and higher costs, employers may pause sponsorship, avoid transfers, or avoid hiring anyone with complexity. That hurts you, but it also hurts the U.S. competitiveness argument in the brief. Let me give you 2 example scenarios, composite examples, not legal advice. Example scenario 1. A Venezuelan software engineer on TPS works at a mid-sized startup. Their TPS EAD is close to expiring, and they assume it will be extended automatically like before. The startup runs an I-9 re-verification and asks for updated work authorization. The engineer cannot provide it in time, so the employer places them on unpaid leave. The engineer then rushes a new plan, maybe a change to another status, maybe an employer petition, maybe a family option. In a surge environment, rushed filings with incomplete documents are where denials happen. The better move is to plan 4 to 6 months ahead, track deadlines, and build a document packet before the emergency. Example scenario 2. An H-1B worker hears rumors of new massive fees and thinks they must file immediately. They pressure their employer to file something that is not actually needed yet, or they accept a job offer from an employer who is not prepared. The petition gets filed with errors, the worker travels while it is pending, and then they hit a border inspection problem. The lesson is not do not file. The lesson is verify the rule, then follow a clean timeline. Now let us move into the most practical part of this video. What to do now with a do this and avoid this checklist. Do this. Make a 1-page timeline of your immigration life. List your current status, your I-94 expiration, your passport expiration, your visa stamp expiration if relevant, your EAD expiration, and every pending case receipt number. If you are in school, add your program end date and OPT dates. If you are employment-based, add your LCA location and job title history. Do this. Download and save your key proof documents offline. That means your approval notices, I-94, EAD card front and back, passport bio page, visa page, and any court documents if you have them. Keep a printed copy for travel days. Do this. Check your case status only on official portals and sign up for official account alerts where available. If you have an immigration court case, track your hearing dates through official channels and keep your address updated. Missing a hearing can create a removal order, and that is one of the fastest ways to go from low risk to high risk. Do this. If you have ever had a prior order, a prior denial, or any contact with enforcement, get your records organized before you travel or file again. That can include old notices, decisions, and entries. Do this. If your work authorization is time-limited, talk to your employer early about re-verification timing and contingency plans. Early planning reduces panic. Avoid this. Do not travel internationally if you are unsure whether you have the right travel authorization or if you have unresolved issues like a prior removal order, long overstay, or a pending change of status that could be abandoned by travel. Travel is where discretion is highest. Avoid this. Do not rely on social media checklists that promise guaranteed protection, fast approvals, or secret shortcuts. In a crackdown environment, bad advice spreads faster than good information. Avoid this. Do not sign or file forms you do not understand. Errors about addresses, dates of entry, prior visas, or prior denials can create misrepresentation issues, which are very hard to fix later. Avoid this. Do not ignore mail from USCIS, immigration court, or a consulate. Missed RFEs and missed appointments are preventable disasters. Here is the part most people miss. The safest move is usually boring. It is documentation, deadlines, and verification. Now, what should you be watching next if the broader story is a clash between borders and economic growth? Watch point 1. Official data releases and definitions. If a number like 2 million is being cited, Look for what the agency counts as a removal, a return, a voluntary departure, or an exit. The interpretation changes with definitions. Watch point 2, court challenges and policy guidance. Programs like TPS often move through litigation, updates, redesignations, and terminations. Guidance can change what counts as valid documentation for employers and DMVs. Watch point 3, processing capacity and backlogs. Surges in enforcement can spill into immigration courts, detention capacity, and USCIS workloads if more people file defensive applications or seek new statuses. That can slow everything down, including legitimate employment-based and family-based cases. Watch point 4, employer behavior. If costs rise or scrutiny increases, employers may file fewer petitions, but also may shift research and hiring abroad. That is the economic time bomb argument. Not that the US collapses tomorrow, but that innovation ecosystems slowly relocate when the pipeline becomes unpredictable. Another myth versus reality before we wrap. Myth. This is only about people who crossed recently. Reality. Enforcement environments can indirectly hit long-term residents through paperwork issues, expired documents, and prior orders they did not know existed. Myth. If you keep your head down, you will be fine. Reality. Sometimes the safest path is proactive compliance, address updates, document renewals, and asking questions before a deadline. Now, let us take a step back to the bigger question in the brief. Is this a safety boost or an economic time bomb? The honest answer is, it depends on the scope and targeting. If enforcement is narrowly focused on serious threats and the legal pathways for talent and families remain functional and predictable, the economic damage is smaller. If enforcement sweeps broadly, creates constant uncertainty for high-skilled workers and long-term residents, and raises barriers in ways that do not actually improve hiring for U.S. workers, then yes, it can push investment and innovation elsewhere over time. And if you are in AI or biotech, timing is everything. Labs, startups, and research teams do not pause the global race. They relocate. So what should you do with this information today? First, do not panic based on a single headline number. Second, do not assume you are safe or unsafe without looking at your actual paperwork and dates. Third, build a plan around verification, official sources, documented deadlines, and conservative travel choices. Let me recap in 5 quick bullets. 1. Removals and self-departures are different, and that difference matters for consequences and for understanding big numbers. 2. The highest risk groups are people with status gaps, prior orders, criminal issues, or travel and inspection exposure. 3. If you rely on TPS or any time-limited protection, your real risk points are work authorization, renewals, and having a backup status plan if eligible. 4. Claims about new H-1B fees or proclamations should be verified on official sources before you make decisions. 5. The safest actions are practical. Organize documents, track expirations, update addresses, respond to mail, and avoid risky travel when uncertain. If you want, comment with your category: student, worker, family-based, TPS, or green card holder, and the one deadline you are most worried about. I will prioritize those scenarios in the next update. And if you want weekly immigration reality checks without fear-mongering, subscribe and turn on notifications so you do not miss the next breakdown.